Good morning, all. We now turn our attention to the legal portion of the course. Uh, that doesn't mean that we're going to yield up ethical ethical issues will fall by the wayside. It just means that our attention will be primarily on legal issues, with ethical issues being I don't want to say a tertiary, but will come up indirectly. So what is the difference? Because I don't have the advantage of having a class to answer my questions, I'll have to ask and answer my questions myself. What is the difference between ethics and law? They both are attempts to articulate, interpret, operationalize, resolve conflicts between ethical principles and values that have evolved throughout the course of human history. Both are attempts at regulating human behavior and protecting society. However, there is an important difference. Ethics emphasizes what we ought to do, OUGHT, or should do. It is often codified in law, but not always. Law, if ethics emphasizes what we ought to do or should do, law emphasizes what you will do. That is, law can be defined as the institutional regulation of behavior by way of rules, threats, sanctions, or threat of sanctions, always predicated upon physical force. And just because something is law doesn't mean that it's necessarily ethical. Blacks and whites couldn't drink out of the same water fountain or enter the same doors. It doesn't mean it by law. In the night, before 1954, that doesn't mean that it's ethically right. So you get that point there, I'm sure. But law is what we will do, or else face sanctions, penalties. I have a boneheaded, love him to death, but at the same time he's a bonehead nephew. He has a wreck, busts out his headlight, and is stopped by the police for having a missing headlight. They issue a ticket, but they tell him if you get the headlight fixed in a specified period of time, indicate that you show the receipt or whatever, some documentation that you've gotten the car fixed, and then submit this by a certain date. You don't have to pay the ticket. He just doesn't pay the ticket. So consequently, the police stop him one night yet again and arrest him for failure to appear. Law is institutional regulation of behavior, supported by rules and threat of sanctions, always predicated upon physical force. Now, in education, I approach the legal issues in education from a teacher standpoint, teacher and student standpoint. I think the emphasis, the emphasis would certainly be different if we operated from an administrator standpoint. It's somewhat different, at least, on key issues. When legal issues arise in public education, at least, they tend to do so around the First Amendment and the rights stipulated by the First Amendment and implied in the First Amendment when we're talking about freedom of association, freedom of speech, freedom of association, freedom of press or assembly, and so on. We'll come back to those. The 14th Amendment, particularly with equal protection and due process clauses. The Fourth Amendment, search and seizures rights. But particularly the two amendments or when legal issues arise in education, for the most part, they deal with the 14th Amendment contractual types of things, 14th Amendment equal protection due process, and the First Amendment academic freedom issues. And so what I want to do today is go through three things. First, I want to define the generic traits of contracts. All of you who are going to be employed in the public schools will sign a contract. You should be aware of the 5 traits that are necessary to establish a contractual agreement between you and a state or a county or district entity. The lack of any one of those traits null and voids the contract. That'll be simple enough, straightforward enough. The second thing I want to do is go through your due process rights while under contract. That'll be important to you. One of you in taking this class will at some point, if you have any longevity in the craft, will find yourself having to understand what your due process rights are, as they are stipulated under and implied under the 14th Amendment. And then finally, I want to go over academic freedom issues, First Amendment issues, and your legal rights, protections, and so on. So this will take a little while. Bear with me. I'll start with an example. In 1989, I was a young fella in 1989. In 1989, I attended the Great Florida Teach-In. There was it was in Orlando at the old conference center and so forth. And I don't know if the state still performs this, but various districts, schools in various districts got together, met in Orlando, and they basically would advertise and then interview people who were interested in teaching in the public schools. So, and I forget if it was Hernando County, Pasco, I can't remember. So I go in, young fellow, male, could teach English to, I want to say, Hernando High School. I can't remember. It's been such a long time, and I'm old. The principal of the school said to me, he looks at my resume quickly, 15 seconds, 20 seconds, says, you're certified to teach English. You can coach wrestling and football. I need all those. If I offered you a job, would you take it? I said, yes, sir. When do I start? And he said, okay. Well, we start you in July. I said, okay. He says, here's my card, my name, number, and I'll get back to you. Does that back and forth constitute a contract? In other words, can contracts be spoken, be oral contracts, or do they have to be written? Well, there were precedent cases before the Harold Loop case that was heard by I think it was Louisiana District of Circuit of Appeal. I don't think it was the Federal Fifth Circuit. I don't think it made it that far. I think it was District Court. But I have things here for you. Look at the first. Loop. Sorry for my low tech here. Loop. Harold Loop versus the Louisiana State School for the Deaf, 1999. In 1997, Harold Loop, who had been a 20-year veteran teacher of the Louisiana school system, and particularly at the Louisiana School for the Deaf, was contacted before the end of the school year by a person who was going to be the principal for the summer school program, basically. She received his name with glowing recommendations and said that he would be a perfect tutor for a student with known behavioral problems and legal issues. being April, had already set up his summer with an extended vacation in the Northeast with his family, and did not want to take the job simply for two reasons. One of which he had already had his summer planned out with his family, and already had put down payments on hotel rooms and had sent money for this vacation, and he was concerned that the student would not show up, and then they would dismiss him. So he would forego his vacation only for a job that probably wouldn't last the contractual period, which was 4 weeks, 4 times per week, so 16 days. The principal assured him that this would not happen, and that they agreed on his regular teacher daily pay, his daily rate, which was $216.80 per day. Loop canceled his vacation and showed up. I think it was over the course of the month of July. Showed up the first 2 days. The student showed up the first 2 days, and at the end of the second day, the student was required by a court of law, the legal system, to attend mental health counseling, and therefore didn't return on the third day, and in fact was not going to return. On the third day, the principal assigned Loop to some desk work, and by the end of the day, the principal informed Loop that the superintendent had informed her that Loop's employment was therefore is terminated for the summer school program. Loop requested a meeting with the superintendent, who said he couldn't meet with him until the following Monday. The superintendent meets with Loop the following Monday, and says that they did not have a contract. That the statement of that first Loop had an agreement with the principal, and then they had signed a memorandum of understanding, a statement of understanding. But that statement of understanding did not constitute a contract, and that the statement of understanding was left to the whims or the discretion of the superintendent, and it did constitute an official contract. After the meeting, Loop requested that they give him any kind of work, because he wanted his full pay over the course of the 4 weeks. They gave him an additional 4 days worth of work, paid him roughly about a little over $1,000 he was owed or due over that contractual period, over $3,000. Loop filed suit. The court the district court in this particular case did several things. Well, did at least 2 things. First, the court maintained that an oral agreement can be an enforceable contract if 5 things are present. And of course, they maintain that at some point a written contract is important just to establish documentation that a contract was entered into. But the court maintained that, in following other court decisions prior, that a verbal contract is just as enforceable as a written contract, as long as 5 generic traits are met. And I'm going to put these up, and then I'm going to walk through these, because they're self-explanatory, but at the same time, I do need to go over these. And here they are: generic traits. Again, sorry for the low tech. Generic traits of teacher's contract. The first is meeting of the minds. I'll come back to that. Second is consideration. Third, legal subject matter. Fourth, competent parties. Fifth, definite terms. Okay. And then there's a 6th, I wouldn't call it a trait, but it's a qualifier on those 5, and I'll give you a couple of examples. I want to give you some examples of these. If any one of these traits, generic traits, is missing from a contract, the contract is not enforceable. First is meeting of the minds. Meeting of the minds simply means that two parties, at least two parties, are recognizing or conscious of the fact that they're entering into a contractual arrangement or discussion, a discussion of contractual arrangement. Seems to be self-explanatory. I'll give an example of my own a little bit later. But they both have to be cognizant of the fact, or they have to recognize, physically recognize, verbally recognize at least, that they're entering into a contractual agreement. I'll give you just an example. I'm standing outside. We at my house we tend to let our grass grow a little higher. I mean, it's a natural Florida yard. You don't want to overcut the grass in the kind of heat that we experience we experience here in the state. It will, it often harms the grass. It burns it and so forth. So we'll tend to let the grass get a little higher. My neighbor, I'm standing at my garage door, and my neighbor says, boy, I'd love to have that grass cut. That's what I say one day as he overhears me. The next day, I come home from work, my grass is cut. Now, this wasn't a contractual agreement. I mean, and then he shows up and says, well, that'd be $20. I didn't say, will you cut my grass and I'll pay you $20. So we didn't enter verbally or explicitly or implicitly any contractual agreement. It was like the dude who walks up and washes your windows at the, this guy. So I pull up one day, and I understand, I understand completely, but I'm sitting at a red light, dude comes over and washes my car windows. Actually makes them worse washes them with a dirty rag, and smudges them up. Then he says that'll be $5. Well, I didn't ask you to do it. I didn't contract with you to wash my windows. So there wasn't a meeting of the minds in the contractual sense. That's what that means. Consideration just means that I'll give up labor for pay, or one party will give up. In a contractual agreement, one party will give up something in return for receiving something. And in most cases, in our current type of society, particularly in terms of a teacher contract, I will give up my labor in return for monetary compensation. Consideration just means trading off of something in a contractual agreement. Legal subject matter. I mean, it just means what it. I can't. That means the contractual agreement will be on the legal. Will be legal, only up and up. I can't contract. I can't, as a principal, as a school district superintendent, I can't have you enter into a contract that either violates your civil rights, which it was determined in the 1960s. I'll give you an example of this, or we can't have a contractual agreement which I am asking you to do something illegal. I'll give you the two examples of that. Legal subject matter. In the 1960s, it was common during the Vietnam War, around at the end of the Vietnam War, to have school teachers sign loyalty oaths. It was as a condition of employment and as a condition of continued employment. As they will be loyal to the United States of America. The courts, when this was put to a legal issue, a legal battle, decided that it is a violation of teachers' First Amendment rights to force them to sign loyalty oaths. As servants as public servants, they have to uphold the law, but they don't have to sign loyalty oaths, and so that was deemed illegal, loyalty oaths, or unconstitutional. I can't, as a condition of employment, require you to give up, as a principal, or an employer can't require you to give up or suspend any of your civil rights, or and so forth. Also, can't require, or districts can't require you to do something illegal. For instance, there was gossip. I don't know if you remember, any of you remember the cheating not scandal, the cheating case in Atlanta several years ago, which a superintendent and I don't know, I want to say 9 to 10 others were charged under the federal racketeering and conspiracy, the RICO laws. Racketeering and conspiracy, that is, and the one of the arguments, though I don't think anyone was charged with this, but it was claimed that the superintendent hired individuals to deliberately manipulate test scores. That's another example of I can't, it's illegal to ask you to do something that is illegal. Legal subject matter is the third. Competent parties just says what it means. It means what it says. Individuals have to be of at least adult age, 18 years of age in this country, and have to be of sound body and mind in order to enter into an enforceable legal contract. I'll come back to that in a second. In indefinite terms. I can't say to you, hey, will you come to work for me? I have to specify as a principal or an administrator or as a district, the contract has to specify the type of work, duration of work, rate of pay, and then for most of you, in this state at least, you will sign an abridged version of a larger or longer arbitrated contract. I think your bargaining unit, though you don't, this is a right to work state, so you're not required to be part of the union, but the teachers unions do bargain are the bargaining agents for teachers, and so they'll in that longer contract, and it's important at some point to read the longer contract. That contract will stipulate rights, tenure laws, which in this state, it's an annual contract anymore. As of July 2011, I believe everyone who was not grandfathered in or after that date, who was hired after that date, is hired on the condition of 1-year contracts. We'll come back to that in a few seconds. Now, meeting of the minds. Let me give you an example. If any one of these generic traits is missing, then the contract is not enforceable. It's important and let me just give you this advice here on the law test. A couple things on the law test. Most of it's straightforward. The answers to the questions or the prompts can be found directly in the text. Pay particular attention to what the prompt is asking of you. If it says to explain, explain. Don't list. For example, you'll see a question that says, briefly explain the 5 generic traits of a contract. One of the errors that students have made in the past was simply list those generic traits without briefly explaining each. I take off points for that. Pay attention to what is asked of you. Where it says list, listing is fine. State, listing is fine. But where it says explain, when the prompt says explain or where it says explain, make sure that you're giving an explanation and not simply listing matters. Meeting of the minds. So I got tenure at this place at UCF in 2007. Academic year 2007, that is in the August of 2007. But prior to that, usually in professor's 6 years, sixth year, they start putting together their paperwork to apply for tenure, their portfolios, as we call them. And it was a hard copy portfolio then. Now it's not. It's an electronic portfolio. And so there are several stages through which this portfolio must pass. There's a committee, a tenure and promotion committee at the department level, at the college level, at the university level, and it goes to the provost's office, and then finally it goes to the board of trustees. And at the time, in 2007, we had just one board of trustees at the state level, and not each individual university having its own trustees. Nevertheless, it had to meet, so that portfolio had to be certified through all of those stages. Now, in March March, roughly February or March of 2007. That is, I finally received the final stamp in August of 2007. So several months later, I got, the whole process was finished. But in March, February, March, my department chair holds a meeting at which there were 5 of us around the table, including her. And she says, or he says, I'm sorry, he says, we had been, the meeting was about workload and covering for 2 faculty members who had moved on to other institutions. And these were faculty members who were advisors to program directors, coordinators, program coordinators, and who advised a lot of students and who taught graduate level courses that needed to be covered. And we were dealing with a shortage of personnel to cover these. So they had to be divided in some form or fashion. And so the department chair says, well, Randy can do it. Now, I didn't look at him in the eyes, didn't look up, because I figured, looking up, I didn't even smile. I didn't laugh. It was quite humorous. Yeah, Randy can do it. I didn't smile, didn't laugh, didn't acknowledge the comment, because by virtue of even smiling, I thought it would be taken or construed as a meeting of the minds, an acknowledgement of entering into a contractual agreement. Didn't say a word. That happened 3 or 4 times in a 2-hour period. I looked down the entire time. Guess what? When the college, when we start back each academic year in August, the college will have a big meeting, what we call the big meeting, or it'll have a college-wide, a gathering of the professors and instructional, all the staff before classes begin, usually the Thursday or Friday before students come back. And typical, at the time at least, this has been quite, 10 years ago, but typical at the time, the following Monday, a report will come out, or of who is the program coordinators of who are the program coordinators, committee work, and all this stuff. Guess whose name was on the program as a program coordinator? Yeah, so I have to go to him. And I say, I never agreed to any of that. In fact, if you remember, I'm telling him this, you made the comment that Randy will be program coordinator. I'll teach all these. I'll take up the slack for 3 classes, and I'll be an advisor to 120 people. You said that 3 or 4 times throughout the course of the 2-hour period during that meeting, and I never once looked up. I never even smiled, because I feared that if I'd had, you would have misconstrued it as accepting the task. Agreed. You did not. Therefore, there was no meeting of the minds, I say. Okay, but will you do it? And I say, yeah, I'll do it. If you add $10,000 to my base, and I'm required to teach just 2 courses each semester. And of course, when hell freezes over, as they say, that wasn't happening. $10,000 to my base. Nevertheless, so guess whose name was taken right off? And I loved my department chair. The department chair meant no harm to me at all. It was very kind and helpful to me throughout the whole process. Those are some example, as an example of meeting of the minds. One final, competent parties. I always use the example because I like to use the example. I went to graduate school at the University of Florida, and at the time, there was a woman who was, several years ahead of me, was in her, and who was a very accomplished graduate student. That is, she had several publications prior to graduating, had won the dissertation. She eventually won the Dissertation of the Year award at the University of Florida, which is a big deal, and was well liked by professors, fairly well known by her in her professional organizations, philosophy of ed society, the regional ed society, and so forth. Uh, uh, excuse me. And so in her last year, she was completing her dissertation. She started to apply for jobs around October, September, October. Uh, and the little schools, the smaller schools, tend to send out their advertisements early. That is, they want to catch, if they can, they want to draw in, catch people, so to speak, quicker, earlier, because they feel that they simply can't be as competitive with the larger institutions. And so she applied to numerous jobs. Numerous jobs, philosophy of ed. When I say numerous, I'm talking about 8 for philosophy of education. Nevertheless, and mostly small schools. University of Alabama was one of the bigger schools. I can't remember. I can't remember what they all were, but University of Georgia, University of Tennessee were the bigger schools, but smaller places like Winthrop University, Troy University, Southeast Missouri State University, and she applied to several places, and she goes to one of her, I think it was, I want to say December, or she also applied to her, what she called her dream school, which is the University of Nevada, Las Vegas. Now, she wanted to go there for whatever reason, but she thought she had no, and that was toward the end of the applying for job period. That is December, January. So I think in January she goes to one of her regional conferences, and she had friends. She had been doing this for 3 years. She'd been going to conferences for 3 or 4 years. Was well known, well received by her colleagues, people who were already professors. They had, in fact, helped publish a couple things that she had done. So she goes to a conference, delivers a paper, at the end of which a couple people in the audience who worked at one of the smaller schools ask her to go to dinner. She says, they're friends. Sure, they go to dinner. And around dinner, right after the session, so right at dinner, they ask her, if we offered you a job at this university, would you take it? She figured, just on the spur of the moment, she said, yeah. They said, well, we have the contract right here. So she basically signs a memorandum of understanding sitting at the table. She gets back, and about 2 weeks later, she gets a call from University of Nevada, Las Vegas, saying that, would you come, you're on the short list, that is the top 3, would you come for an interview? She goes for an interview, they offer the job. She says, I'll take it. Thinking that, well, the people who offer me a job at the smaller school are friends of mine. They will understand. They know I want to go there, and they will basically null and void the contract, the memorandum of understanding. Well, they didn't. Now she's got a problem. They didn't. They were actually mad. It's a big deal to conduct a search, shut down the search, now only to have to reopen it again. And there's a lot of bureaucratic, will, so to speak, to shut down and then get moving again. So they were not happy at all. In fact, they were going to sue her for a year's salary and legal fees. So it just so happened. So now she's got a problem. It just so happened that at that dinner, when they took her to dinner, she was picking up the table because they had left it a mess for the waitress. She had done that kind of work while in graduate school, and knew, that it was not right to leave the mess the way they did. And so she just started picking things up, paper she'd shove in her little briefcase. Just so happened that she had put shoved old receipts from the table into her briefcase, and they were drinking at the the people who took her to dinner, they had P cards, purchase cards for the university, from that they represented, which they represented, and the purchase card would pay for meals, but it wouldn't pay for alcohol. So the particular individuals bought the alcohol, and she had swiped up their receipt, the itemized receipt, and used that as a means to say that she was not a competent party at the time, and that she felt that she was drunk. They were drinking. She was tipsy and felt under duress, and so got out of that that agreement. Now the six qualifying. So if any one of these generic traits is missing, the contract is null and void. And even if all these generic traits are there, there's one final qualifier, and it's not a generic trait of a contract. It's just a qualifier. Jesse Wilson, I'll give the Jesse Wilson case, and I don't know Wilson versus something, but Jesse Wilson in the late 1960s. Jesse Wilson was a principal who contracted in the D.C. area to teach, to be the principal or head administrator for one of the local D.C. public schools. She applied, she applied, got the job. They sent her a notice saying that she had been accepted as the head principal or principal at one of the local D.C. schools, only to receive a couple of weeks or maybe a month later, only to receive a notice that she would have to reapply. She filed suit saying that they had a contractual agreement and that the district breached or broke the contract. That all the generic characteristics, the generic traits of a contract had been met. The court ruled that the final stamp, that the contract had not been certified or ratified or certified by the school board. And until the school board, ultimately the final authority, certifies it, then there is no contract. So even if those traits are present, the school board is the final authority. If the final authority doesn't certify the contract, then it's not an enforceable contract. That actually happened to me when we moved back from Arizona to my wife and I. My wife was pregnant with our second baby when I was teaching school in Arizona, and we moved back to my home state of South Carolina to have the baby. And we figured, well, let's just stay here, just stay where we are. And so, 2 kids, 26 years old. I need a job, so I get a job at the local high school. I want to teach English, coach football, coach wrestling. They need someone to open the gym, starting the weight room starting in July. Say okay, get the key, sign the contract. Only we just couldn't do it. It's hard to move. What is it? Thomas Wolfe, look homeward, angel. You can't go home again. And so we had to get the hell out of there. So I called the principal up, who had been very kind to me and still is, and told him I couldn't do it. Well, the school board hadn't met and hadn't ratified the contract. Therefore, I got out of the contract. It wasn't a breach. Now, breach. Just let me quickly go over breach. Breach, you'll see an item on the test that says define breach. I don't have it in front of me. Define breach and give an example of a breach of contract and a legal breach of contract. Now, breach just implies breaking a contract, but and so I use legal breach as a means to recognize that there are times when breaking a contract or the stipulations or the breaking a contract is a fine or legal thing to do. Of course, breaking a contract, a breach of a contract means that terms of the agreement are violated. For instance, terms of the agreement are violated or extended. For instance, I use this example of I'm teaching high school. A fellow English teacher, I'll just use English, is easy enough, is pregnant, has to be out for a better part of the semester, and we're not hiring another person. We'll just cover her. The school has decided just to cover her classes with the existing staff, instructional staff or faculty that it has. And therefore assigns me an additional 2 classes of 25 students apiece. It's an additional 50 students. Well, that does extend somewhat. I mean, to a substantial degree, particularly if you're graded, if you just depending on the nature of the work, it extends my workload, and so that does interrupt at least my existing contractual agreement. I can come back and say, well, yeah, I'll do it for for additional pay. But if I'm assigned that additional pay, or if it's held against me that I won't take it without that additional pay, then that is somewhat of a breach of due process and a breach of a contract. Legal breach. So if I don't show up to work, that's a breach of contract. If either party fails to adhere to the terms, conditions of the contract, then of course it is a breach. Legal breach. There are times and conditions which the absolving a contract is necessary. For instance, when we had I had a friend who worked in the Panhandle, physics teacher who had been teaching in the Panhandle High School, and I had Panhandle High School for 30 years. But he had a degenerative eye problem that got precipitously worse over a matter of months. So he goes from not good vision to almost blind in one eye, not being able to drive to work, and then not being able to see at all in a matter of from August to October. Very quickly. It happened very quickly, in other words. He wasn't able to continue. It was impossible for him to continue to work there. So impossibility of performance is a set of conditions, one reason to absolve contract, and then just mutual assent. Impossibility of performance. Sometimes you can, now we take medical leave for pregnancy and so forth, but any kind of health issue, for instance, may render it impossible to perform the duties required under the contract. And then just sometimes mutual assent. For instance, and I can give you some for instances, but there are times at which both parties just agree to not continue the arrangement. I worked with a 9th grade English teacher on the Navajo reservation, in the public school on the Navajo reservation, who came into the school. I don't want to say complaining, but she didn't come into the school complaining, but she saw right away that she had too many students, not enough aides, not enough resources, and the school had plenty of financial resources to meet her needs. They continued not to meet her needs. She continued to complain, and finally filed a letter of resignation right before the winter, we call it a Christmas break, the winter break. Being understaffed, they pleaded with her not to take the Christmas break, relax. Things would be corrected once they got back. She said okay. She rescinded her letter of resignation. She then goes on break, comes back. Things weren't corrected, and within 2 months she files it again, and they said, you know what, just go, which she did. So you can absolve a contract via mutual assent. Now to due process rights. Let me start here, and I'm going to run this about 55 minutes or so, break this, and then start another one just because it's easier for me to load and to contain, the caves, the caves, the size of the file. Now, teachers' due process rights during in the teachers have rights during the contractual period. It used to be, tenure. Tenure is. We'll get at tenure in a few minutes. You'll see on the test to define tenure and the rights of tenure. Now, tenure was an old, what tenure means, what tenure has meant and continues to mean, is that that a teacher has performed at such a level as to certify that he or she is minimally competent and meets or is working to meet the standards of the school. And that after a probationary period of time, the person is granted a special holding status, for continued employment. What tenure really means is that a person's 14th Amendment due process rights always apply, even when not in session, when school is, in the summer. We'll come back to that in a second. Let me just read the 14th Amendment, and I'm going to read it fully. All persons, 14th Amendment reads this way: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And of course, the last clause is considered the Equal Protection Clause, and then the one prior: no state shall deprive any person of life, liberty, or property without due process. And so, teachers, even though you all are on annual contracts, principal, you can't just be fired at will during that contractual period. You have staked, as well as the state has, but you have staked your life, liberty, and property on this job. Just like Harold Loop, he gave up something, his labor, in return for something. You give up life, liberty, and property. You stake your life, liberty, and property on this employment. You plan for the future, at least for a year, on the basis of this employment. And so it can't just be pulled out from under you at the whim. There are due process, and that due process basically amounts, and I don't know what page this is in your text, but there are certain procedural rights that have to be adhered to. Now, what are the conditions under which? Teachers can only be terminated for due cause. During the contractual period. Now, tenure meant that a teacher's due process rights always applied. During an annual contract, it just simply means during the contractual period, your due process rights apply. Now, administrators and districts can start the termination process if they have cause, and we can identify two types of causes. One type of cause is that which cannot be remediated, and that's anything that's, you harm a student in any physical or mental way. Harming a student, for instance, I'm loath to say this, teachers having sexual relationships with their students. That cannot be remediated. Physically harming a student, taping their mouth shut, or taping them to a chair, which has been teachers have been guilty of doing. things that you can't take back, can't be remediated, and it often is the case that, felonies, depending on the types of felonies and depending on the situation or the circumstance. I know this gets into a gray area, but nevertheless, felonies are often seen as irremediable offenses. Irremediable offenses basically are you're signing your termination. You're entitled to due process. That is a hearing. I'll go through the procedural rights of due process here in a second, but if it comes to pass, well, you're entitled, even for remedial offenses, non-remediable offenses such as harming a student or felonies. Teachers are they are merited or warranted due process. They're entitled to due process rights, and then there are remedial offenses. Remedial offenses refer to things that can be, of course, corrected, remediated. Let me see if I can find some of these things. Reasons for dismissal that can be remediated to some degree is insubordination, incompetency, or reasons for dismissal. But typically, insubordination, incompetency, immoral conduct unbecoming to a teacher, those are shades of remedial and non-remedial. But typically what happens in schools, the vast majority of for cause cases are for remediable offenses. That is, things such as not knowing subject matter, poor classroom management, not showing up on time, insubordinations, types of insubordinations. There are gray areas there, don't get me wrong. Things that can be corrected. And so what typically happens is that in those cases, the school and school board will provide notice of infraction and an opportunity for the teacher to correct such problems over a specified period of time. And if those corrections have not been made, then the termination process starts. But when the test asks you to explain the due process rights of teachers, what it means is to explain the procedural rights of teachers. That is, when your due process rights is that you have to are as follows. There should be an issue of statement of charges and basic information upon which charges rest. 2, if requested, there must be a hearing before school board or hearing officer designated by school board. 3, written notice of time, date, and place of meeting. 4, a public hearing. 5, opportunity to be represented by legal counsel. 6, opportunity to call witnesses. 7, opportunity to cross-examine witnesses. Opportunity to examine evidence. 4, there has to be a reporter of such a meeting, and then finally a written, because I've forgotten numerically what I'm on, a written decision of facts, conclusions, and the right to appeal. Those are the due process rights of teachers. Let me stop here. I want to get, it's important to know what these rights are. Of course, you're going to have access to legal counsel, probably. I mean, if you have to invoke your 14th Amendment due process rights, it's important to have some general knowledge of what these rights are. I was going to say I'll give you an example, but I don't think you need an example on this point. What I want to do in the next video is then work through academic tenure, academic freedom, and then what academic freedom entails as protected by the First Amendment. Okay.